If you would introduce yourself so we know who we have here. The states put their notice in saying that they weren't going to be arguing.
Good morning, Your Honors. May it please the Court, my name is Alan Balls, and I represent Kim Nelson, David Malone, in the law office of David Malone.
Okay.
Good morning, Your Honors. I'm Chris Brown. I'm here for years and
Okay. Obviously, we have nobody here for the appellant, but they were well aware of that, or he was well aware of that. So y'all are free to argue as you wish, or however you want to do it. But you're here, so you're certainly free to argue. And if you are going to argue, have you divided the time up?
You can go.
30 seconds, huh?
30 seconds.
trying to hold myself to that. Good morning, Your Honors. May it please the Court. I'm not sure why my clients are involved here. The complaint in this case was filed July 25th.
Excuse me, do you
Yes.
really mean 30 seconds?
Probably 30 seconds.
Give him a minute.
One minute. That'll be fine. Thank you very much. The complaint was filed July 25th, 2019. We filed a motion to dismiss under Rule 12.026 on September 12, 2019. That motion was granted August 24th, 2020, and our clients were dismissed. Thereafter, Ms. Nelson filed the motion under the Abusive Civil Action Act, trying to get the plaintiff classified as an abusive civil litigant. We were no longer involved in that case. We were already gone. We got dragged into this by being served with the notice of appeal. There are no claims made against my clients in this case. We think the appeal is frivolous as to us.
And you didn't ask for anything, you didn't file anything under the ACA?
Correct.
All right.
If the Court has any questions, I'd be glad to address those.
I hear none.
Thank you, Your Honors.
I think you actually did it.
30 seconds.
Good morning, Your Honors, and I don't believe that I'm going to need the full 15 minutes, but
We only have 14.
14. I don't think I'm going to need all that time, but
Yes.
so I believe that this is the 8th appeal that this court has heard in the last 7 years involving Mr. Justice and my client, Ms. Nelson, in some capacity. And so I believe that this court is very familiar with the dispute between those parties, as well as the briefing in this case having been extensive on multiple issues. So it's my intent to be fairly brief in recapping the background relevant to this case, address some of the issues presented in the briefs, and answer any questions that this panel may have. It was actually about 20 years ago this year that the litigation between these parties began with what should have been a relatively straightforward parentage action in Roane County Juvenile Court. And instead it spawned multiple lawsuits by Mr. Justice against Ms. Nelson and the attorneys representing her over the years. And this is one such similar lawsuit, and actually arises out of 2019 when this court affirmed judgments against Mr. Justice totaling over $400,000. During the course of that year, Mr. Justice tried to sell his condo, and in the process discovered that Ms. Nelson and her attorneys had recorded a judgment lien in 2017. Mr. Justice then filed this lawsuit in Knox County Chancery Court for claims of extortion, abusive process, and conspiracy. And the theory underlying all of those claims was this idea of a wrongful execution, that just by filing the judgment lien with the Knox County Register of Deeds, that constituted an execution under Rule of Civil Procedure 5907. Over the course of the next year, the trial court had granted motions to dismiss, including that of the Mears defendants, reasoning that there was no improper execution. And for her part, Ms. Nelson filed a motion under the Tennessee Abusive Civil Action Statute, asking the court to classify this lawsuit as an abusive lawsuit and impose primarily sanctions in the form of a prohibition on filing any new lawsuits against Ms. Nelson for a period of 48 to 72 months as provided under Section 106 of the statute. And so central to this case is the interpretation of that statute. It is Tennessee Code Title 29, Chapter 41, Section 101 through 107. This is actually a noteworthy statute that's received praise throughout the country as a creative solution to a phenomenon called stalking by way of the courts, in which abusers manipulate litigation to harass and intimidate victims even after they've escaped their abusers. It's been called a model legislation for the other 49 states, and in fact, a very similar version of it was recently enacted in Washington in 2020. It is a statutory counterclaim that may be raised by answer or motion, and as I said before, it allows victims to pursue a remedy that is very meaningful to them, which is a pause for 4 to 6 years of having any more lawsuits filed against them. And so my purpose here
Counsel,
today...
Let me go ahead and kind of direct you to a particular issue. The trial court in its order referenced the Roane County Juvenile Court's order finding Mr. Justice being an abusive civil action litigant, and talked about the presumption, and then said plaintiff Justice failed to rebut the presumption. After that, if I'm correct, this court reversed that juvenile court's decision on that. Is that right?
Yes, Your Honor.
Where does that leave us? If the trial court relied on that presumption, that rebuttable presumption, and found it wasn't rebutted, where does that leave us?
Well, I believe that the court may affirm for multiple reasons. First of which is that the statute itself says for the rebuttable presumption in Section 105 that the presumption is raised at the time of the hearing. At that time, Mr. Justice and his counsel did not raise any objection to introduction of that order for the purpose of raising a rebuttable presumption as being a non-final order. Did not even mention that it was on appeal. Furthermore, that argument, any argument thereon, was waived thereafter. And as this court noted in an order when the plaintiff appellant asked this court to summarily rule in its favor in a motion last year, this court noted that he did not move for any relief under Rule 60, still has not. That order was valid under the statute at the time. It was valid evidence. And even if the court were to disagree, as stated in our briefing, there was still ample unrebutted evidence at the hearing. Mr. Justice did not call any witnesses, did not introduce any affidavits. The only evidence in the record supports still a finding that he was and is an abusive civil action plaintiff. And if the court has any more questions on that issue, I'd be happy to address those. But the issues that I wanted to address with this court today were primarily as it relates to Mr. Justice's claim that the non-suit that he took after Ms. Nelson filed her motion deprived the court of jurisdiction to entertain it, as well as whether or not the statute requires the alleged abusive action to be the same or similar to a prior action. As this court is very aware, with Lacey versus Cox, the seminal case on this issue by the Tennessee Supreme Court in 2004, a plaintiff's right to voluntarily dismiss is subject to the exceptions explicitly stated in Rule of Civil Procedure 41.01, as well as an implied exception where the non-suit would deprive a defendant of a vested right. In that rule, it states that if a counterclaim has been pleaded prior to the plaintiff taking a non-suit, the defendant may proceed with their counterclaim. And that is exactly the situation that happened here. The abusive civil action statute in Section 103 explicitly refers to a movement's right to make a claim pursuant to answer or motion. The section is even entitled Claim Asserting Abusive Civil Action, How and When Raised. And if that were not enough, the Tennessee Supreme Court also said in Ray Tanner in 2009 that it is a key principle of statutory construction to apply the plain language of the statute without complicating the task further. But even if the statutory text were not enough, looking at the legislative history, the General Assembly was explicit in stating that the purpose of the statute was to create a civil cause of action. And so here, Ms. Nelson pled a counterclaim, and that counterclaim could not be destroyed by virtue of the plaintiff thereafter taking a non-suit. And if that were not enough, also under the plain language of the statute, by this point in time in the litigation, Ms. Nelson had a vested right in having her motion heard. Finally, the plaintiff appellant raises in his briefing this issue of the statute requiring the abusive civil action being the same or similar to the prior one. And he claims that because this case involved an improper lien and not the parentage action involved in the Roane County Juvenile Court, these cannot be the same or similar, and therefore it's not an abusive action. That analysis muddies the waters. In reality, the definition of an abusive civil action under Section 101 defines it as an action filed by a plaintiff against a defendant with whom the plaintiff shares a civil action party relationship, in other words, an intimate familial relationship, including being a parent of a child together, primarily to harass or maliciously injure the defendant, and at least one of the following is relevant. Either claims or allegations are not warranted by existing law, factual contentions are without evidentiary support, or an issue or issues that are the basis of the civil action have previously been filed in one or more other courts and disposed of unfavorably to the plaintiff. Where the plaintiff appellant seems to go awry in his analysis is in reading Section 105 regarding rebuttable presumptions as being a requirement. There in subsection 1, a court may find a rebuttable presumption if the case that is alleged to be an abusive civil action raises the same or substantially similar issues as a case in which those issues were litigated unfavorably. That is not the case here. That was not a contention and not an issue raised before the trial court, not the basis of the opinion. And moreover, that rebuttable presumption, it's not a requirement. And so we would maintain that given the evidence in the record, the arguments made before the trial court, whether or not the rebuttable presumption could have been relied upon, there was plenty in the record to support a finding that Mr. Justice was an abusive plaintiff. I'd be happy to address any questions with the time remaining.
I hear none.
Thank you.
Thank you. We appreciate your argument this morning, especially yours. 30 seconds. Call the next case, please.
In re of Kurt R. et al.